Jackson.
Well, good morning, ladies and gentlemen. Please remain standing for the playing of the national anthem, the flag to your right. Please be seated. Let me begin by welcoming our distinguished guest and speaker, Supreme Court Justice Ruth Bader Ginsburg.
Thank you. Thank you. That's enough.
Justice Ginsburg, welcome to Lexington and to the Virginia Military Institute. And I also extend a warm welcome to the students and faculty of Washington Lee University and its School of Law, and the members of our local community. Thank you for being here today. We are honored to join with our neighboring institution, Washington Lee University, to host Justice Ginsburg at today's public session held here at Cameron Hall. She will be formally introduced in a few moments by Johanna Bond, Associate Dean and Professor of Law at Washington Lee University, but allow me to make a few preliminary comments. We have been fortunate in the past years to have Justices Thomas, Scalia, and O'Connor speak to the Corps of Cadets, and certainly their varied views provided an expansive and insightful perspective. Through her long service as a most prominent member of our nation's highest court, Justice Ginsburg has delivered considered judgments on some of our country's most perplexing legal issues involving the United States Constitution. Every citizen has a duty to be familiar with this vital document, and today is a rare opportunity for us to learn from a sitting justice much more about how judicial decisions involving the Constitution are made. I was impressed by Justice Ginsburg's words spoken at a judicial conference in memory of Justice Scalia following his recent passing, and later repeated in the Journal of the Supreme Court Historical Society, in which she referred to the words of the operatic duet that she and Justice Scalia once sang together, and that was entitled, "We Are Different, We Are One." And Justice Ginsburg concluded, and I quote, "Yes, different in our interpretation of written text, but one in respect and affection for each other, and above all, our reverence for the Constitution and for the Supreme Court." It is most appropriate that we welcome today a member of our nation's highest court and notable example of a citizen with a lifelong dedication to public service. VMI's central mission is to produce educated, informed, and honorable young men and women who possess the knowledge and the skills and the personal strength to be exceptional leaders. At the same time, our graduates are prepared as citizen soldiers to defend our nation in time of peril. The mission of public service has remained a cornerstone of our educational program since the Institute's founding in 1839. And our neighbors attending Washington Lee School of Law share a similar commitment in defending the nation and the high principles upon which it was founded through the study of the Constitution and through the study of its legal processes. Graduates of their School of Law labor to preserve our nation's democratic system of government and basic freedoms by advocating for the rule of law throughout our society. Again, thank you so much for your attendance today. It is now my pleasure to introduce Bryant Hellwig, Dean of the Washington Lee University School of Law. Dean Hellwig.
Good morning. My name is Bryant Hellwig, and I have the privilege of serving as Dean of the Washington Lee University School of Law. On behalf of the law school, I would like to express our deep appreciation to General P and the Virginia Military Institute community for hosting this event on your campus in such a wonderful setting. We at Washington and Lee are proud to be your academic neighbor, and we at the law school in particular are pleased to have graduates of your institution among our student body and in the ranks of our alumni. It has been a true privilege for our law school to work with members of the VMI administration in crafting today's joint visit from Justice Ginsburg. Justice Ginsburg, it is truly an honor to have you here with us today. Thank you for visiting both of our institutions, for taking time to meet with our students and members of our faculties, and for conducting this public interview. This is an exciting event for our law school, for our university, and for that matter, the entire Lexington community. At this point, I'd like to turn the floor over to my colleague on the Washington and Lee Law faculty, Joanna Bond, who in many ways has been the driving force behind this event. Dean Bond will graciously provide a more detailed introduction of Justice Ginsburg and her biographers. Thank you very much.
It gives me great pleasure to introduce to you this morning 3 remarkable women. 2 of them, Mary Hartnett and Wendy Williams, are Justice Ginsburg's authorized biographers. They are both accomplished, dedicated lawyers who've been working for decades to improve women's rights around the world. Professor Wendy Williams of Georgetown Law School has known Justice Ruth Bader Ginsburg since the 1970s when they litigated women's rights cases. Professor Williams was a founder of Equal Rights Advocates in San Francisco, one of the premier public interest law firms in the country. She helped draft the Pregnancy Discrimination Act and the Family and Medical Leave Act. Professor Williams' important contributions to feminist legal theory and her advocacy efforts have helped countless women who were navigating and who continue to navigate between the demands of professional employment and family responsibility. Mary Hartnett, an adjunct professor at Georgetown, was for many years the director of the Women's Law and Public Policy Fellowship Program. In that role, she has mentored and inspired many young attorneys in the US and abroad to devote their professional lives to social justice. For almost a decade before that, she was of counsel at the international law firm Couder Brothers. Professor Hartnett also served as a public policy fellow at the Woodrow Wilson International Center. Each of these women is a visionary with a relentless drive to make the world a better place. They've conducted numerous interviews in support of their 2 books about Justice Ginsburg. My Own Words, authored with Justice Ginsburg and released in 2016, and a yet-to-be-released biography. Both of these women shaped my thinking as a lawyer and a feminist scholar, particularly in my early days of law teaching at Georgetown. They inspired me and guided me, but most importantly, they became lifelong friends. It is a great honor to introduce Justice Ruth Bader Ginsburg. Justice Ginsburg was born and raised in Brooklyn, New York, and received her bachelor's degree from Cornell in 1954. She then married, had her first child, daughter Jane, and promptly went to Harvard Law School, where she was one of 9 women in a class of 500. Family circumstances led her to transfer to Columbia, where she graduated at the top of her class. After a prestigious judicial clerkship with Judge Edmund Palmieri in U.S. District Court for the Southern District of New York, Justice Ginsburg took her first teaching job at Rutgers Law, then moved to Columbia, where she became the first female tenured law professor. While at Columbia, Justice Ginsburg became the director of and counsel to the Women's Rights Project of the ACLU, where she was the architect of a highly successful litigation strategy to promote women's rights. After unprecedented success as a women's rights litigator and great acclaim as a law professor, Justice Ginsburg was appointed by President Carter to serve on the U.S. Court of Appeals for the District of Columbia in 1980. In 1993, President Clinton appointed her to the U.S. Supreme Court. It is impossible to capture the range and depth of her contributions to American jurisprudence in a short introduction. In her judicial writing, her style is precise but eloquent, always deeply grounded in the facts, and never divorced from human experience. In critical jurisprudential moments, she has resisted American insularity and opted instead for appeals to comparative and international law. Her contributions to social justice and gender equality have been profound. Her promotion of gender equality rights as a skilled and strategic litigator, as a pioneering teacher and mentor, and as a careful and visionary jurist has been life-changing for generations of women who came after her, including many of the women in this room. The U.S. versus Virginia case, which invalidated VMI's all-male admissions policy, is an important part of that legacy and makes Justice Ginsburg's visit today, 20 years after that decision, even more poignant. And so it is with the deepest admiration that I welcome her here today. Please join me in welcoming Justice Ruth Bader Ginsburg.
Thank you. Thank you. Thank you. Thank you.
On behalf of all 3 of us, thank you all for this invitation. We're thrilled to be here today. Justice Ginsburg, I thought we might start by asking you a question about an activity that I think is near and dear to the Cadet Corps here, which is PT, physical training. And I'm wondering if you'll share with us your own PT regime.
I have a personal trainer who has been with me since 1999. He is today the personal trainer of 3 Supreme Court justices. After me, Justice Kagan, and then most recently, Justice Breyer. And he does his best to keep us all in shape.
Could you tell us a little bit more about your workout routine? We won't ask you to show us, I promise.
Well, it's an hour, and in about the first segment, there are push-ups and something called a plank. And then there are various weights to lift. We do this at a time of day, it's between 7 and 8, so I can watch the news hour while we're going through our paces.
Justice Ginsburg's trainer, by the way, is a member of the reserves.
Yes.
And so you were without him for some time when he was
Yes,
called
he was
into service.
3 years in Kuwait. So, but he found a substitute for me
Good.
during those years.
Now, Justice Ginsburg can do 20 push-ups, but I'm going to annotate this so that Justice Ginsburg doesn't tell me I'm exaggerating. Justice Ginsburg does 10 push-ups, and she does not do the so-called girl push-ups. She does not use her knees. And then she stretches back for a very brief pause, and she does 10 more. And one time when I was introducing Justice Ginsburg, one time when I was introducing Justice Ginsburg, I said that she could do 20 push-ups, and after I sat down, she said, "Mary, that's actually not completely true. I do 10, then I pause, and I do 10 more," which tells you as much about Justice Ginsburg's modesty as it does about her physical fitness. But Justice Ginsburg, as we heard from Joanna, we know you grew up in Brooklyn in a working class neighborhood, the daughter and granddaughter of immigrants, and went to public elementary and high school. And then you went on to college, about the age of most of the young cadets here, on a full scholarship to Cornell University. I'm wondering if you would share with the audience a little bit about your time at Cornell and what inspired you to pursue law as a profession.
Cornell was a preferred school for daughters because in those happily no longer days, there was a strict quota for women. There were 4 men to every woman, and so families felt if she can't find her man here, she's hopeless. But I luckily did find my man when we were, and he was extraordinary for the 50s because he thought he cared that I had a brain. Most young men of that time didn't. And he was, throughout our 56-year marriage, he was always my biggest booster. He thought my work was at least as important as his. And he was also a superb cook. But you asked about the atmosphere at Cornell in the 50s, the early 50s, 1950 to 54. It was not a good time for the United States. There was a Red Scare in the country, and there was a Senate Internal Security Committee, a House Un-American Activities Committee, calling people to account for some organization they joined in their youth, many of them at the height of the Depression. I was taking constitutional law and also working as an assistant to the distinguished professor of constitutional law. He wanted me to appreciate that our country was straying from its most basic values, and those are the right to think, speak, and write as you believe, and not as a big brother government tells you is the right way to think or believe. And then he pointed out that lawyers were standing up to people, many of them from the entertainment industry, when they were called to appear before Congress. And then I got the idea that law was a pretty nifty profession. You could work to earn a living, but you could also do something that would make your society a little better. You could devote your talents to something outside yourself. Well, little did I know in those pre-Title VII days that most law firms were not interested in employing lady lawyers. My family had some reservations about this. But then when I married at the end of my last year in college, my family said, well, she wants to be a lawyer, let her try. If she can't succeed, she will have a husband to support her. So my marriage, far from being a detriment, was a tremendous asset, as was having a daughter. My 2 years of my life was spent at Fort Sill, Oklahoma, when my husband was an artillery officer. And during that time, my child was born, and she was 14 months when I started law school. There was a balance to my life that many of my fellow students did not have. They were so concentrated on the study of law and nothing else. But my day was divided. I would work hard at the law school, and then 4 o'clock, when the babysitter went home, was my daughter's time. Each part of my life, I thought, was a respite from the other. So by the time Jane went to bed, I was quite content to go back to the books.
That's great. And you mentioned, I think most of the audience probably didn't know that you lived on a military base for 2 years.
We lived in Artillery Village,
Right.
yes, in Wary Housing, it was called.
That was right. And there's a funny story about Marty, because when he first arrived at Fort Sill, he was first going to be assigned to actually go into combat, and it turned out he had no experience, and he went in to meet, and maybe you can tell the story.
Well, Marty had been in the first 2 years of ROTC were compulsory at Cornell, and the second 2 years were voluntary. Marty, when he was asked to fill out the form, do you want to go into senior ROTC, he wrote on the form, hell no. But then there was the Korean War, and he decided, all things considered, maybe he should be in senior ROTC. Cornell had a quartermaster corps. Marty, for some reason we never discovered, was assigned to the artillery base at Fort Sill. And he reports to the commanding officer, asks about his training at Cornell, and he said, well, to tell the truth, that what's out in your backyard is the first artillery piece I've ever seen. And the officer said, young man, that is a fence post. But Marty had 2 skills that equipped him for the artillery school. One is he was very good at math, and a lot of trigonometry is involved in the artillery. The other was he could judge distance on the ground. I mean, if truth be told, Marty majored in golf when he was at Cornell, and he was on the varsity team. So he could, when they're adjusting fire, and he could say, that's a 5-iron. So he ended up, I think he was highest passing man ever in the artillery school, and when he graduated, they made him an instructor of gunnery. And we spent the balance of our time at Fort Sill.
Wonderful. Then law school, you were one of 9 women in the entering class at Harvard. Could you share with us a little bit about what it was like to be one of very few women at the time?
Yes, but first, can I say something about our Army days? There was something extraordinary that the Army was doing. My child spent her first year in the nursery school, the officers' nursery school. This was a facility for children from 2 months to 9 months. And even though my daughter was there till 12 months and the nurses liked her so much, they kept her in the 2 months to 9 months instead of 9 months to 2 years. But this was, the word daycare wasn't even coined in the United States. And there was that facility right there at the Army base. You could take a child there at 8 in the morning you could keep the child all day if you wanted to, as long as you came by midnight. But then I had a rude awakening when we moved to Cambridge, Massachusetts, and there was no daycare facility at all. So how did it feel to be one of 9 women in a class of over 500 men? You felt you were constantly on display. So if you were called on in class, you felt that if you failed, if you didn't perform well, you were failing not just for yourself, but for all women. It also had the uncomfortable feeling that you were being watched throughout the class. And then there was the dean's famous dinner for the women in the first year class. After dinner at his home, he asked each of us to stand up and tell him in turn what we were doing, taking a seat that could be occupied by a man. Well, this was a dean who had been an ardent supporter of the admission of women to Harvard Law School. 1950-51 was the first year of women at the law school. And he said he asked that question not to embarrass or wound, but there were still people on his faculty, doubting Thomases, who thought it was unwise to admit women. So he asked the question so he would have stories from the women themselves about what they would do with their law degree.
So it's hard to believe that it's been over 20 years since you penned the majority opinion that opened up VMI to women. And Wendy's going to ask you some questions in a minute about that. But first, I wonder if we could show the audience what you're wearing today, something special.
This is a Keydet pin that I received from someone who was in the audience today. He wrote to me that this pin was given to the mother of every man in the graduating class. And when his mother died, he thought I might like to have the pin. He thought she would be proud if I would wear it.
And I thought I would read. I thought I would read a brief excerpt of your exchange of letters. This cadet graduated over 30 years, or almost 30 years before the decision. On graduation day, 1967, mothers of the class of 67 were given Keydet pins. The one enclosed was my mother's. She is dead now. We want you to have it. In an abstract way, you will be mother of VMI's first and succeeding women graduates. This pin makes you an adjunct member of the VMI family. I am sure it would have made my mother proud to know it is in your possession. Feel free to wear it proudly, anytime, but especially if you were ever invited to VMI. Be of good spirit. Love, tolerance, and compassion will someday prevail without laws to mandate them. And Justice Ginsburg responded to the alumni and to his daughter, who also signed the letter. I will wear your grandmother's Keydet pin proudly at Charlottesville this weekend on a visit to the University of Virginia. This was in 1997. Then Justice Ginsburg went on to say, perhaps by the year 2010, I will wear it even more proudly at VMI. There we go. And that alumni is in the audience today, but he's a very modest person, and we will not identify him at his request, but we're very happy he's here. Then finally, for this bobblehead, for those of you that don't know, the Green Bay Law Journal, Professor Ross Davies designs bobbleheads of many figures and justices of the Supreme Court. And here is Justice Ginsburg. And there's something significant about this bobblehead, actually two things. Would you like to describe to the audience? Can you see?
Well, the base of it, not the law book, but this green, is supposed to be the campus of VMI. And then this safe relates to a case, much more recent case, the case of Lily Ledbetter, who was an area manager at a Goodyear tire plant. And she brought her case to the Supreme Court because she found out that her pay was considerably lower than every man who was doing that job. So in that safe, there are 13 pennies representing how much less per hour Lily Ledbetter earned than her male colleagues.
No. So Justice Ginsburg is standing on the VMI parade ground, which actually is on the reporter that the VMI decision is published in. So VMI gets double billing in the Ruth Bader Ginsburg bobblehead.
Is there a third reason? You're holding,
Good.
I think she's holding something here, and it's cases from the Supreme Court, and it is the volume in which the VMI case appeared. So that's also part of this bobblehead.
So, Wendy.
Yes, well, I know you've all read the case and studied it carefully, am I right?
Wendy, it's very long.
So I thought maybe we could start by just having her, or one of you, a volunteer, give us the basis of the case. Never mind. Ruth. What is the case about? Very briefly, in a word or 10, what did the Supreme Court hold in that case?
And well, first I should say the title of the case is United States against Virginia.
Virginia.
So it was not an individual woman, although there were several women who wanted to apply to VMI, but it was the United States government that was saying the state of Virginia could not support a facility that provided an opportunity to men only, just as it couldn't to women only. I should say that there was a forerunner to the VMI case. The case was titled Mississippi University for Women against Hogan. Hogan was a man who wanted to be a nurse, and the best nursing college in his area was the Mississippi University for Women. At the end of her first year as a member of the Supreme Court, Justice O'Connor wrote an opinion saying Mississippi could not maintain this facility for women only. And so it was that precedent that paved the way for the VMI case of some 15 years later. Both cases made the same point, that government can't prefer men or can't prefer women for an opportunity, that all doors must be open to our sons and daughters, and they will choose to enter those doors if they have the will and the talent to do so. But without Mississippi University for Women, it would have been much harder. Now, by the time we get to United States against Virginia, the decision, at least the bottom line judgment, was almost unanimous. It's true that at the time, Justice Thomas was recused because his son was attending VMI. Justice Scalia ended up as the sole dissenter. And if you read the opinions, mine is the sole simplicity, saying there are women who are ready, willing, and able to undergo the tough training at VMI, and they want that opportunity. The state of Virginia can't deny it to them. Scalia wrote a rather attention-grabbing dissent. But people who know the two of us, we went through, I think, the final version that came out was something like the 17th or 18th draft, because Scalia and I were going back and forth like a ping pong game. But the first time I saw the draft of his dissent, he came into my chambers and he threw down a sheaf of paper and said, "Ruth, this is the penultimate draft of my dissent in the VMI case. I'm not yet ready to circulate it to the full court, but I want to give you as much time as I can to respond to it." And that's the kind of colleague he was.
You've said that he, in fact, improved your product because you got to respond to him
Yes.
in more detail.
The ultimate opinion was much better than the first draft because he picked up on all of the soft spots and enabled me to make the opinion stronger than it would have been absent his, as I said, attention-grabbing dissent.
Well, his very first sentence of that dissent says, VMI is dead. You know, this kills VMI. Would you like to comment on that prediction?
Well, I knew it wouldn't. It would make VMI a better place. One of the exhilarating things for me in my lifetime is to see how the military has opened opportunities for women. There was a highly restrictive quota for women originally. Most occupational specialties were closed to them. But with a little assistance from litigation, I mean, it was another case that was a forerunner for the VMI decision, was a case against the military academies. It never came to the Supreme Court because the government, early on in the litigation, decided they would rather switch than fight. So then West Point, Annapolis, the Air Force Academy, they began to accept women. But there was something like at least 10 years of women at the military academies before the VMI case came to the Supreme Court. So we really were able to see that the military academies were alive and well, and it was easy to predict that the same would happen to VMI.
Now, I have two sons, beloved sons, and you have one. And some of the young men at VMI were not thrilled at this coming change. And what would you say to those young men?
I think they learned from their women classmates how much good women could do for the institution. Now, I know that there were some people who did not react well to the change. In fact, I have here a letter that was written by, it's kind of a poem, written by a friend of VMI shortly after the decision. It's long, and I won't read more than the first verse, but it goes this way. A scampering of dainty feet is heard across the plain. The VMI Cadet Corps is on parade again. I broke a nail. Oh, I could cry. A cuddly corporal shrieks. A buxom sergeant dabs her eyes to blot mascara's streaks. Captain Bertha splits a seam. These pants weren't made for girls. Oh, darn this perm, cries Private Pam, and struggles with her curls. So flouncing out, the tittering throng lines up at Stonewall's feet. Feminists triumphant, their victory complete. Now, the women of VMI surely know that they don't resemble any of the women described here. And my response to this was, wait and see. You will be proud of the women who become graduates of VMI.
Could you just take a minute to talk about Justice Scalia and your general experience with him? Anybody who read that dissenting opinion would think that he really didn't like you anymore. And so I would like to clear up the nature of your relationship just a little bit.
I have been fond of Justice Scalia since the days we were both law teachers, and then we became colleagues on the D.C. Circuit. What we share in common, we both care not only about getting it right, getting our decision right, and sometimes his idea of right was not the same as mine, but how it is expressed. We both spent a lot of time trying to write our opinions so that even people who aren't lawyers will understand them. We also cared a lot about family, so that was another bond we had. And yet another was our love of opera. Now, Scalia was way ahead of me in that regard because he had quite a nice tenor voice, and I am a monotone. Nonetheless, we were supers at the Washington National Opera a few times. I miss him very much. I say, without him, the court is a paler place because he brought such zest to our discussions. But to give you an idea of the exchange in the VMI case, so I had a footnote that referred to the University of Virginia at Charlottesville. He snapped back with a footnote that said, there is no University of Virginia at Charlottesville. There is only the University of Virginia.
Show the picture. Yeah. We do have a picture here of you with Justice Scalia, both at the opera and on an elephant, for those who would like to see.
Notice who's sitting in front and who's sitting in back.
Yes, and my feminist friends questioned that. Why is Scalia in the front of the elephant? I said, the driver said it has to do with the distribution of weight.
Well, there's so much we could talk about having to do with VMI, but we are going to have to move on. So I wonder if there are any last thoughts or words you want to say about that case.
It was an important precedent for the court. There were many years that the court never saw a gender-based discrimination it didn't like. I mean, the history of the court up until the, quote, liberal Warren Court in 1961, the Warren Court said it was all right to keep women off juries in Louisiana because, after all, they were the center of home and family life. Never mind the defendant in this case, Gwendolyn Hoyt, was a woman who had an abusive, philandering husband. One day, he was so abusive, he humiliated her to the breaking point. She picked up her young son's baseball bat, hit her husband over the head. He fell to a stone floor. That was the end of their altercation. It was the beginning of the murder prosecution. And Gwendolyn Hoyt was from Hillsborough County, Florida, which did not call women for jury duty. Her idea was, if there were women on my jury, they probably wouldn't acquit me, but they might convict me of the lesser offense of manslaughter rather than murder. She was convicted of murder by an all-male jury. She argued that the absence of women on her jury denied her due process of law and the equal protection of the laws. And the Supreme Court's attitude in 1961 was, why, women have the best of both worlds. Yes, they're not on the jury rolls to start with, but if they want to volunteer to serve, all they need to do is go to the court clerk's office and sign up. Well, how many people would sign up for jury duty if they could escape it? 10 years later, there had been a huge change in our country in the way people were living. There were many more two-earner families, and the court was able to understand in the 70s what it couldn't understand earlier. Earlier, the court's jurisprudence was a gender line in the law is okay as long as it's rational. As I put it, as long as it could pass the lunacy test. But by the time we got to VMI established that a gender-based classification could not survive unless the government showed an exceedingly persuasive justification. So instead of presuming that the law was constitutional, there was the opposite presumption. The defender of any sex line in the law had to establish an exceedingly persuasive justification. And that was an important advance made in the VMI decision.
So it's fair to say that VMI didn't just make a huge difference to VMI, but has lasting importance on a doctrinal level for people of the United States.
Yes.
Mrs. Ginsburg, thank you so much for sharing your insights with us today. On behalf of VMI, Corps of Cadets, the faculty and staff, as well as Washington and Lee and its School of Law, we'd like to present you with these tokens of our appreciation.
They're going to come to you. They're going to come.
Oh, okay, okay.
He'll bring them.
Thank you so much. Thank you. Thank you. Thank you very much. Should I open them here?
Can she open it?
Oh, I can. Okay.
We can help you.
Maybe
Maybe
you
we-
could take the
Sure.
paper
And
of
maybe we
this.
can get a cadet to help.
Would you help us open these, young man?
This one.
All right. Yeah, no problem. And you can present it to the justice. Oh, beautiful.
Oh, isn't that beautiful?
Excellent.
This will be placed on a shelf just behind my desk, and I am very proud to put it there. And this is from Washington and Lee. It's a beautiful silver cup.
It says something on it.
Washington and Lee Law.
Ladies and gentlemen, this concludes today's proceedings. Please remain in your seats until after the departure of the stage party.
Good job.